Very good evening to all of you. So tonight we would like to discuss something briefly for just about 5 minutes, and then we are done. One of you sent me a message on the backstage on WhatsApp, and she sent the questions that were run as a trial exams for Central University. Now, those of you who are on the platform, you saw that some students were sending advertisement of a mock or trial exams, which was being taken and which was being organized by Central University. So once one of your colleagues sent it to me, that I said, okay, let's spend some time tonight. Let's go through the questions and discuss. As I keep telling you, so far as a topic or question related to the 6 examinable subject areas or the modules, I do not think that anything is useless or anything is not looking at. Everything is relevant so long as it pertains to the land law, Ghana legal system, contract, constitutional law, torts, and criminal law, I think, and of course the law of tort. Yeah. So anything related to that, I think, is relevant because you don't know which question is coming. So you just be very well prepared on anything, have a good understanding so that you'll still be able to deal with any issue. So without wasting time, so just for the sake of those who have just joined us, this is the question that they did recently at the Central University. I think by some of those who are attending some of the either classes or whatever. But one of you sent a question. So unfortunately, this is what I have. So as you can see, I've actually opened a WhatsApp, right? This is a WhatsApp I've opened on the screen because I don't have like the regular PDF. So forgive me for the infelicities or lack of neatness in how the screen is. Unless the most important thing is what is there, so let's make do with that. So question 1, where an occupier fails to take reasonable steps to ensure that the contractor is qualified and therefore competent for the job, he is not liable under Occupiers Liability. True or false? Indicate your answer in the, of course, this one is either true or false. So, but what is your take before we discuss it? Okay, let me see. Okay, so now, before we move on, sorry, this is, we just have to, sorry about this. Yeah, so remember the law on the Occupiers Liability, right? Let me just quickly say a few words about the law on Occupiers Liability. The area of torts, which requires that if you are the owner of a premises or you are the person in charge of a premises, then the law imposes an obligation on you to ensure that those who come to the premises are reasonably safe. But in terms of how safe you are to assure those who come to the premises, it will depend upon a number of things. But just as a quick revision, we will have to explain who an occupier is to start with. And occupier is, as we have stated, liable for incidents on the structure of the premises, but who is that person? Who is that person? Well, if you look at the literature, I think the most popular way is the guidance Lord Denning has provided. And I will just the definition Lord Denning has provided in the case of the wheat against Lacon Limited. Lord Denning had the following to say, and I quote, whenever a person has a sufficient degree, those of you who have my late Professor of Facebook, right? Those who have Professor of Facebook, you can go to page 232, may so rest in peace. Yeah. So, quote, whenever a person has a sufficient degree of control over premises, that he realize that any failure on his part to use care may result in injury to a person coming lawfully there, then he is an occupier, and the person coming lawfully there is his visitor. So that is, if you like, the basic statement of the principle on occupiers liability. And having said that, still in the same case of wheat against Lacon Limited, wheat as in the food wheat that we eat, and then the Lacon Limited is a Lacon, Lacon Limited. Still in that case, decided in 1966, Lord Denning proceeded to identify 4 types of occupiers. So 1, a landlord who lets the premises by demise has parted with control of the premises. So the tenant is the occupier. So despite the fact that you are a tenant, you could be treated as an occupier for purposes of occupiers liability. So meaning that it's not only the landlord who could be an occupier for purposes of occupiers liability. And 2, a landlord who lets part of a building but retains other parts. Example, the common staircase remains as occupier for the parts of the building that he has retained. So maybe you have maybe like a story building or something like that, and you have rented apartments in it, and you have also retained maybe some other site for your own use. And then we have like the common staircase. For the parts of the building that you have retained, you will be the occupier in respect of that. But of course, the other part that you have let, the tenant will be the occupier in respect of that. Now, the third category or the third type of occupier, according to Lord Denning's statement in the Wheat and Lacon Limited, is that a landlord who licenses a person to use his premises on terms that do not amount to a demise, but still has a right to enter onto the premises to do repairs, remains sufficiently in control to be the occupier. Okay, so so this will most likely take care of what they call like the licensee, right? You're a landlord, you can grant a license to someone to be on your land. Just like, let's say like the hostel, right? You take the hostel accommodation on university campuses. The hostel is owned by the landlord or whoever owns it. And the students that are there have been given the license, as it were, to occupy it. Nevertheless, the landlord reserves the right to go to those places or premises where the students are occupying to see to repair work or make sure that things are in order. So that could fit under the third type of occupier Lord Denning is identifying. And for that matter, that landlord will still be considered an occupier, despite the fact that he has licensed a person to be on the premises. Yeah, then the fourth category, where independent contractors are employed to do work on the premises, the owner will generally retain sufficient control to be the occupier. And this will depend upon the amount of control that the contractors have while the work is in progress. Yeah, so the third category of occupier relates to where you have a premises and you are giving work to independent contractor. You still retain your status and, for that matter, responsibility as an occupier, despite the fact that you have brought independent contractors to do work on the premises. But of course, that is not cut and dry, and is very much dependent upon the degree of control which the contractor, while the work is in the progress, so that if the independent contractor has got more control during the pendency or as the work is in progress, he has a more control over the premises and all that, then it may not be very simple for you to conclude that it is the one who awarded the contract, who, or the owner of the premises, who is the occupier for purposes of occupiers liability. So these are some of the general things that we have to keep in mind as far as occupiers liability is concerned, in terms of who qualifies to be an occupier. And of course, in that respect, we have been using another terminology, the premises, because to talk about occupiers liability, we're also talking about like the premises. And if we talk about the premises has a very broad meaning. It does not relate only to, if you like, just a house. Because if we look at the authorities, the term premises is defined to include any fixed or movable structures, such as taxis, boxes, vessels, vehicles or aircraft, railway carriages, gangways, and scaffolding. So the most important thing is that the defendant should have retained control over them, as opposed to the position in negligence at common law, where the defendant may be liable for harm done by dangerous actions, which he has ceased to have control. So long as the particular thing you're referring to as the premises can be demonstrated to have been under sufficient or significant control of the occupier, then it will suffice as a premises. Then we also talk about like a visitor. When we say a visitor, it's important in discussion of occupiers liability, because we know that the occupier has a common duty of care towards all visitors. A common duty of care towards all visitors. So who are visitors then? So visitors, we include invitees, licensees, as well as those who have a contractual right. That is a contractual entrance, where there is no contractual duty of care. So therefore, where a person enters under contractual right, the common duty of care will be implied into the contract, unless the contract expressly provides for a higher standard of care. So these are some of the things that I would like you to keep in mind as we encounter occupiers liability in our discussion of questions from, as I said, Central University, right? But since Yeah, so let's come back to the question then. Where an occupier fails to take reasonable steps to ensure that the contractor is qualified and therefore competent for the job, he is not liable under occupiers liability. True or false? Now, being an occupier, if you are bringing a contractor, right? You are bringing a contractor to do a job. Do you have a duty of care? Do you have an obligation to ensure that the contractor that you give the work to is competent to be able to do the job? Let me look at the answers that you have. Some of you, some are saying that you should try and speed. As I keep telling you, I'm not interested in just the having, the questions have been published and they are there and they've even been answered. So in terms of just covering everything, you can just go through that. But as I said, we use the question just to provide the scope for discussion. So that is what we do. Okay, so let me allow those of you whose hands are up, because some are saying false, others are saying true. I'd like to know why you think that there's no duty, and those, yeah. So those who said false and those who said true, at least let's get one each to defend your answers, then we conclude on it. Josh and then Davidson.
Hello, Doc.
Yes.
I would have chosen false. And even proceed to dispute the definition of a contractor to mean just somebody you have contracted to render a service to. So I believe that what I have, or the limit to which I know a contractor is defined in the law of tort would mean, for example, where, say you run a bar, for instance, all the people who come there to patronize your services are kind of contractors for you. So in a sense, you owe them a duty to ensure that your place is such that at the end of the day, those people will not get injured or nothing untoward will happen to them. That is my understanding of a contractor, rather than a person who have awarded a kind of physical contract to come and perform. Thank you.
Okay, so in that case, you are going for A. Is that your answer?
Yes, false.
Oh, all right, B, right. Okay, all right. So let me take Davidson.
Yeah, so say from your reading, I could get the knowledge that at times, okay, not necessarily from your reading, but I just also, like we concurred at a point that you may be a mere occupier who may not be skilled or even have knowledge of the contractor. Okay, but the emphasis of the law is that you should have reasonable control over the premises. So if I have control over the premises and I don't have knowledge, or let's say I'm an illiterate, not having knowledge about the contractor will not put blame on me more. Onto my premises and left. Whether he was competent to do the job or not, he has come and he has gone. No liability.
So your answer is what? Your answer is B, or false or true, Davidson? Okay, now we've lost him, but let's let's take his response and that of the other gentleman who spoke earlier. And he said that he understands contractor to be like anybody who has come to the premises and all that. But if you look at the question is talking, as also linking to like to a job, isn't it? So we are not just talking about just anybody who has come there just for any type of contractual transaction, to come and buy something and go or something like that. No. The way the question is framed suggests that it's taking your mind to, yes, who's Davidson, your hand is, okay, Nenebi. Your hand is up.
Hello, sir. Sir, good evening.
Good evening.
Yes, sir. If you look at the case of Haseldin versus CA Door and Sons Limited.
Okay.
The court was of the view that if the occupier has taken reasonable steps that he ought to have taken to satisfy himself that he has entrusted the work into a very competent hands of an independent contractor, then when there is any breach of duty of care, the occupier will not be held liable. So, on the strength of this case, I will take the question to be true.
Take the question to be true.
It's not. Yes.
Okay, all right. Thank you. David says your hand still up.
Yeah, I was saying that I couldn't unmute, but it's true. I was going for true.
All right. Okay. Yeah. So if you understand the contractor and then the job in the question to mean that the reference is to independent contractor, then you have an obligation. Let's suppose that you have like a premises, there's a major work, you've allow someone or awarded it to someone just to come there and who doesn't have any clue as to how that particular work is done, and he ends up creating various hazards to other visitors to that premises and also neighboring premises and all that. Then you will be liable for those dangers which have been created, as it were. Of course, the only caveat is that, I mean, so long as independent contractor, I think you have the responsibility, and that is why the emphasis like the reasonable steps. Okay, let's move on. Per the dictum of Lord Moulton in Rickard and Lothian, the view ascribed to the term non-natural use under the rule in Rylands and Fletcher is, can anybody tell us the principle in Rylands and Fletcher before we answer the question itself? What is the principle in the Rylands and Fletcher? Very basic thought concept. Okay, only the two people, the same people. And the rest don't want to contribute. Okay, Nenebe and then Davidson when he's done. So Nenebe.
Okay, sir. So the principle under the
Rylands and Fletcher, or the rule in Rylands and Fletcher.
The principle under the Rylands and Fletcher is that if an occupier or puts his land in a non-natural use and that thing escapes, and after escaping has caused damage to a neighbor, he will be held liable under the principle of Rylands and Fletcher. In the case of AG versus Coke, the court held even human beings to be teens, because some boys were kept on the land, and on the blind side of the occupier, they escaped and went and caused damage to the adjoining neighbor. And the court said that the human beings can be held to be things in that regard.
Why did the court say that human beings can be held to be things? Maybe, why did the court come to that conclusion? Oh, is it gone? Okay. Yes, W, yeah, you can talk. If we muted you. Yeah, if we lose you, yes.
Okay, so the principle in Rylands and Fletcher is to the effect that if a person puts his land in an unnatural use where he accumulates a thing that is likely to cause mischief when it escapes from that land, is liable for any damage that causes to another person. And so the case itself, Rylands and Fletcher, where the defendant accumulated water in a reservoir, which escaped and then flooded the mines of the plaintiff, the court held that he was liable for the damage that was caused in the mine. Thank you.
Right, thank you very much. This is the first female voice for the evening. Good, so let's come back to the question. How did Lord Moten describe non-natural use requirement and the principle in Rylands and Fletcher in the case of Rickard against Lodian? Ellen, I think your hand is up. Okay. Yes, you've been released. Please go ahead. Ellen, you can mute yourself. Is your hand up?
No, I think, no, it's a mistake. Sorry.
Right. Yeah, so what answers are there? Let me see. 2C. We have one answer. Let me see more. Ajua, Ani. Okay, Charlotte. C. Okay. Ascribed to the term non-natural user is ordinary, extravagant, special, indiscriminate. Now, this is a type of question which we call like the what do you call like a sort of like a penalty shot, in the sense that if you apply the elimination method, it may not work very well because some of the words have similar input. Of course, extravagant could also mean extravagant. So it's like, it's a type of question that you either know or you don't know. Yeah, so it's allowed to call like the context specific question. The context specific question in the sense that if you haven't read Rickard Lothian and the opinion of Lord Moten, you will not know how he described the non-natural use, that it should be special. That is not a use which is very ordinary, which is very natural to that particular place where the accumulation is supposed to be taking place. So it's the kind of thing that you know or you don't know, but you often don't get so many of such cases. Yeah, so then we come to another type of either you know or you don't know type of question again. Question 3, the rule in Rylands and Fletcher was first formulated at the Sheka Chamber by. So just we are being tested regarding the judge who first propounded the principle in Rylands and Fletcher. And again, it's also the type of question that you either know or you don't know. So my advice in preparing so to be able to answer these type of questions is that there are certain principles, certain concepts which are so common. So for those principles or concepts which lay down in the certain case law, it is useful to be able to link the particular judges who did that. So for example, we mentioned promissory estoppel. You can right away remember if it's high risk case, Denning, right? We mentioned the neighbor principle or the general principle on the duty of care. You can right away remember Lord Atkin in what do you call the Donoghue and what and Stevenson. And so all that I am suggesting is that for various topics, you will try and become familiar with the key cases, right? The leading authorities, and then try and know the judges who are associated with those particular leading authorities. And once you do that, I think you should be fine. If they'll be bringing this type of question at all, it will not be from what we call the obscure type of case law. It will be from like the leading authorities. So here, if you look at the report, all the judges over there, we have, okay, let me see the answers that you have. Okay, Blackburn J. Okay, so the case was, it started from the lower court, made its way right up to the House of Laws. And of course, is I highlight the full judgment before me. I want to make a specific information from. Okay, I will send it to you. Yeah, so Rylands and Fletcher, the Exchequer wrote. Yeah, so we have the Lord Cranworth. Then we have Mr. Justice Blackburn. Of course, that was the Exchequer decision before it got to the House of Law. So the B will have it. But if we look at it, because there was a further appeal, so we have the law. So that if you look at the other names that we have, the Lord Cairns. Lord Cairns sat on the appeal, but the original formulation was a decision from the lower court, which was given a blessing by the appellate court. So just like if you take like Hadley and Basindel, is a decision from a very lower court, Baronal decision, before later on it will be given blessing by the highest court. So I will send the judgment to you. So in that respect, Blackburn J is the one who is first associated, and the emphasis is first formulated. That is the emphasis, like first formulated. 4, which of the following is not qualification for a sole commissioner of inquiry. Yeah, somebody was asking me a question about commission of inquiry and the effects of decision of commission of inquiry today. And I was told that I have some authorities on that. I will send some materials on commission of inquiry for you. So, but remember that I've asked you to be reading the Constitution about 1 month ago. And those who heeded my advice, I'm sure now you've read the Constitution 2 times. So you very much know some of these specific constitutional law questions. So, in which provision of the Constitution do we have commission of inquiry? Anybody? Well, I'm sure you'll be shy to tell us whether you have finished reading the Constitution. But which provision do you have commission of inquiry? Anybody? Yes. Ni? Yeah, Ni?
278.
278.
Article 278. Yeah.
And don't mute yourself. So who can, at whose instance can commission of inquiry be set up?
Come again.
Who can trigger the setting up of commission of inquiry?
The President of the Republic.
Under what circumstance?
Under a complaint, or under if there's a complaint or something is happening in the country, and people are agitating, the President can set up a commission of inquiry to investigate, to find out the facts, and then report to him.
Okay, thank you. Thank you, Ni. But like, if you go to the 278, as you rightly said, the President is the one who can make an order or who can trigger by constitutional instrument the setting up of commission of inquiry. But we have to know the 3 instances, because the 3 instances are there. The driving criterion is that the matter which is going to be the subject of inquiry by the commission of inquiry should be something of public interest. And the question is, how do we determine whether something is a matter of public interest? So 3 scenarios have been provided in 2781. That is the ABC. The President is satisfied that something is in the as a matter of public interest, whether there's a commission of inquiry, or the Council of States advise the President that something is in the public interest, or Parliament by a resolution request for the setting up of a commission of inquiry into any matter which they consider as being a matter of public importance. So look at it. In the case of Parliament, the driving word there is not public interest, public what? Importance. Although one will argue that public interest is coterminous with the public importance, but that is not necessarily so. Something may be of public importance, but may not necessarily be a public interest as defined in the Constitution. But these are the instances that the President can set up commission of inquiry. And as I'll be telling you, if you be reading like the provision we have in question 4, the qualification, everything is there. The 278, you go to 2782 and 2783. If you be reading the provision, it's a kind of question that you right away have your answer. Edi Muhayu, yeah, you want to say something?
Hello, Doc.
Yes.
Yes, I want to ask a question on this. I think the second leg, the condition, the one the Council of State advises the President that he should set up a commission of inquiry because the matter is of public interest.
Yes.
And that whether he's bound by that advice to necessarily set up the commission of inquiry. I'm asking this against the backdrop of the Richard Sky case, where the Supreme Court held that the President is not bound by the advice from the Council of State. Is the Article 278 advice an exception from what the Supreme Court decided in the Richard Sky case? I just want to know generally advice, the effect of the advice from Council of State.
So the interpretation of the advice that the Supreme Court gave will apply in all instances where advice is contemplated under the Constitution. So it's not only the case that when it comes to like appointments, maybe appointment of judges or appointment of anything that the Judicial Council or the Council of State is supposed to advise, and no. So wherever advice is contemplated, the interpretation that they gave is that, yes, you have an obligation to be advised, but you don't have obligation to follow the advice. Because if otherwise, they've given the advice, but that doesn't mean that you must necessarily go strictly by the advice if you think that there are some other reasons for which, but you must be seen. You must be seen to have actually obtained advice or be advised as it were. Okay, thank you. Yeah, so if you look at the 278.3, the qualifications issues are there. A person shall not be appointed a sole commissioner or chairman of commission of inquiry under this unless he is a justice of the Court of Judicature. So that is from the High Court, Court of Appeal, Supreme Court, or B, a person qualified to be appointed a justice of Superior Court of Judicature, or C, a person who has held office as a justice of the Superior Court of Judicature, or D, a person who possesses special qualification or knowledge in respect of the matter being investigated. Okay, so let's apply that to the options that we have. What answer did you put there? It is your hand still up.
Yeah, but I just don't want us to drag, because when you look at where the Council of State is mentioned in the Constitution, it's either, usually when it comes to appointment, it says the president shall do this in consultation with the Council of State, on the advice of the Council of State, and all of that. In all, it has to do with consultation and all of that, on our advice. But with 278, it's emphatic. It says shall constitute a commission of inquiry. So it does appear that the operative word shall, the president shall, suggests that the president is bound by the advice, because that is the only provision in the Constitution where we are told that the president shall, on the advice of the Council of State, do that. I guess probably the Supreme Court need to interpret that. That's really the point. It's different from the on the advice, in consultation, and in accordance. No. That of the language here is the operative word is shall. So I think with that one, he ought to be bound by that advice based on the interpretation of shall. But that's just my have the opinion. Really.
Yeah, right. Edi, I like your reasoning, except that if we compare the Council of State, right, with that of Parliament, in the case of Parliament, we see that the Constitution is quite specific in terms of that they have to pass like a resolution, isn't it? And quorum, the requirement and all that will have to be met. But for, of course, but the argument will also be that if the Council of State doesn't have like the quorum, then they cannot do their work and also prefer any advice. Yeah, so I very much appreciate your reasoning, but for now, we don't have any authoritative pronouncement as far as I can recall regarding 278(1)(b). So it is still up for creative reasoning like the one that you have done. So that is very fine. Okay, so the options. A justice of the Superior Court of Judicature, or a person who qualifies to be appointed as a justice. Of course, what we read is true. I mean, the answers there, some of them are just B, a PhD holder. I mean, that is irrelevant. It's nowhere in the law. A person, C, a person who possesses special knowledge in the matter being investigated. Okay. D, none of the above. So which of the following is not a qualification? The the person who, the examiner who put this question together is also creating some difficulties, because if you look at the options there, certainly B is the answer. But if you go back to how the question is formulated, having regard to D, none of the above, is also an option. But how the question is, which of the following is not a qualification? So certainly the answer is B, but the inclusion of the D brings some kind of like ambiguity into the, yes. Edi, you want to speak?
Oh,
Edi?
no.
All right.
No, no.
All right. Your hand is all right. Yeah, so 5, which of the following is not a component of the common law as explained under Article 11 of the Constitution? Yeah, so this is also a very straightforward question. And I'm sure everybody here, nobody here will get it wrong. So let me see some 10 responses in the chat. Look, put your answers there. 5, question 5. Question 5, can I see some responses? Okay, Deborah, Nokia. Okay, I have a 2 category of answers. Some students opted for B, others opted for D. So let's come back to, sorry about this confusion because of how I got the question through the WhatsApp. Now, so rules of common law, is it a component of the common law as explained at Article 11? Yes. B, rules of equity, yes, it's a component. C, Ghanaian customary law, yes, it's a component. And D, legislation, that is not a component. So as I said, that is obvious. So the common law of Ghana has 3 components: the original received common law, the doctrines of equity, and then principles of customary law. Is your hand up? Is your hand up, Eddie? Is it up or by mistake? Is your hand up? Okay, let me. Okay, let's move on. 6. Look at the next one. The next page is not turning. This is, how do you get the next one? Yes. Okay, so we have the next one. This is, I don't know if you can see. It's not expanding. Okay, good. Francis, your hand is up. Francis?
Yes, please. Good evening, sir.
Good evening.
I'm only giving a little reaction to the my brother's comment concerning the advice of the Council of State to the President. I think when you refer to Article 91, Clause 3,
Yeah.
it gives an authority that the Council of State may advise the President or the Minister of State on any matter which the President or the Minister is considering, just that the President or the Minister will not be expected to act in accordance with that advice. So the Council of State may give the advice, all right, but I think it's the prerogative of the President or the Minister whether or not to act in accordance with that advice. I'm sure that was the basis of the Supreme Court holding in the case that he referred to.
All right. All right. Thank you very much. Thank you.
Thank you, sir.
Yeah, so let's look at this. Which of the following is not the source of law under our constitution? So Article 11 is something that should be obvious to everyone. You have to know it inside out. The sources of law quite straightforward. So A, existing law. When you say existing law, can anybody tell us what existing law is? What is existing law? Anybody? Existing law. Okay, existing law. Okay, let's Saint Mugai. I haven't heard you today, or he's gone. Okay, no, existing law.
Yes, sir. Good evening. Yeah, existing laws can be described as laws that existed prior to the coming into force of the 1992 Constitution, which are not inconsistent with the provisions of the 1992 Constitution. So the NRCD decrees, the PNDC laws, the SMCDs, they are all existing laws. But the ones that are not inconsistent with the 1992 Constitution are considered as existing law and they are still in operation.
Okay, that is good, but I'll give you probably 9 or let's say 8/10. There's something else you have to add. So let me see if anybody will add. FJA.
Okay, so good evening.
Good.
Maybe we forgot to say written and unwritten laws.
Okay, you add one, just maybe 0.5 to the score, but still there's something crucial missing. There's something crucial missing. Let's see. Okay.
Okay.
You want to try again? Okay, so let's.
Yeah.
Okay, what is?
Maybe after and the laws which are after the Constitution.
Yes, you are there. You have the idea, but I want it to be put in a very clear and direct way.
Okay, written and unwritten laws of Ghana that existed before the coming into force of the 1992 Constitution, such as Act.
Oh, right. Okay, I'm fine. I mean, in that case, I think I I've been teaching this particular area so many years, and I'll be reading subconsciously. I'll be reading something into the provision which is not there, and that is why I said I'm not giving him the 10 marks. But I think I'm being very hard unnecessarily in that respect. Like for ease of understanding or comprehension, I usually prefer that you add. So before the coming into force of the Constitution, that is the critical date before 7th January, isn't it? Because the Constitution came to force on 7th January, so before 7th January 1993. Yeah, so if you add that, it helps us to understand. But as I said, if you look at the provision itself, it is not expressly, the order it says that before the coming into force of the Constitution. So in that respect, you are right. Okay, so don't let us waste time. So thank you very much, all of you, for your good knowledge of what the existing laws are. Let's take, you want to say something? We have some more hands up because we need to continue. I've been requested to run very fast so that we can finish many questions. Yes, Deborah.
Oh, sir, please, I wanted to answer the existing laws, but the lady has answered, so we can move on.
All right, good. Yeah, so which of the following is not the source of law under Constitution? Existing law is a source of law. Orders, rules, and regulations are source of law. And in fact, if you like, the way in which subsidiary legislation or delegated legislation is actually reflected in Article 11 of the Constitution. So the source of law. C, House of Parliament, the source of law. D, history and political books, obviously, they are not a source of law. They could just be, in some cases, extrinsic to some interpretation, but they are not source of law. The Constitution. So the obvious answer is what? Is D. So this is very straightforward. Okay, so I think some hands are up. So let me hear you what you want to say before we move on. Ni, your hand is up. D, your hand is up. Yes, let me hear you.
Okay, thank you, Doc. Article 11.7.
Yes.
Talks about, I've asked this question in certain places, but I'm not clear.
Okay.
Talks about orders, regulation that must be laid in Parliament for 21 days.
Right.
We have other instruments like constitutional instrument and executive instrument. Must it necessarily be laid in Parliament? Because the Constitution is very specific on the orders, rules, orders, and regulations. You know, so sometimes I wonder why, because if you look at the these Guantanamo prisoners that came,
yes,
the president had executive order to bring them in. They didn't lay it before Parliament, and he was in. Then later, the thing went to court, and the court says the agreement must be laid in Parliament. But the court never said the executive instrument must be laid in Parliament for 21 days before it becomes law. So these are some of my challenges.
All right.
The specificity of that.
Right. Thank you very much. You see, I understand your point. First of all, let us understand that Article 11, Clause 7 is providing framework for exercising some oversight, right? Some parliamentary oversight over delegated legislation or subsidiary legislation. And if you say subsidiary legislation or delegated legislation, laws made by bodies or functionaries authorized by Parliament. And it may be in the form of legislative instruments, LI. A legislative instrument make regulations. So the label which is given to the how it is presented, we call it the LI, but what it will contain are actually regulations, as it were. And then, or sometimes you can have rules. The legislative instrument may either contain rules or bylaws, contain rules, or what do you have, like the order. The order could be some constitutional instrument or anything. So these are what we call like the drafting styles, if you like, and we don't have hard and fast rule concerning what type of delegated legislation should be in the form of order and so on, except that if you look at the practice of courts, most of the rules of procedures are often catch as orders, so that you have like the CI 47 or this or the 1 or the 2 or the 81, whatever. You have then even like Supreme Court rules. Sometimes they just use the wording like the rules. They don't even say like the order as it were in Court of Appeal and all that. So there is nothing intrinsically unique as to whether the particular delegated legislation is presented as orders or presented as regulation or as rules. Fundamentally, what is important is as to whether it's made by Parliament or is made by bodies other than Parliament. Now, constitutional instrument is a unique type of delegated legislation or subsidiary legislation in the sense that the power to make constitutional instrument is actually conferred by the Constitution itself, and that is why we say constitutional instrument. So the power to make it is derived from the Constitution. So many independent bodies, and also sometimes even like the executive, just when we're discussing Article 207, Article 8 on Commission of Inquiry not long ago, you see how the president will have to pass CI, constitutional instrument, to actually set up Commission of Inquiry. Of course, the president is not a lawmaker, he doesn't make laws. But when it comes to Commission of Inquiry, he's supposed to do that by a constitutional instrument. And an argument can even be made that there are two categories of constitutional instruments. Of course, that is my argument in the paper which is coming, that one category of constitutional instrument has what we call the legislative character, like a lawmaking type of constitutional instrument, right? Just like maybe like the Electoral Commission, you have to make a rule to govern elections and all that, or you take like the Rules of Court Committee. They will have to make a rules to govern the practice before the courts and all that, and so on and so forth. So those are constitutional instruments which are playing the role of like a law, like a lawmaking. So that's why I say they have a legislative character. But if you have some other forms of constitutional instruments, which actually they have like the effect of what they call executive instruments. They are not different from what the executive instrument really do, except that here is a constitution which is saying that to do a particular thing, you must have a CI. So for example, when it comes to exercise of eminent domain of the state, that is the compulsory acquisition. I think if I remember very well, yeah, Article 20. That when it comes to compulsory acquisition, for example, you notice that part of the requirements for doing so, I think there's an instrument supposed to. I'm just trying to look at the sub-clause, the particular clause, and the okay, shall only be made under a law which makes provision of. So this one, it just said like the law. But sometimes, like so, like in practice, you see the states trying. The executive will make an executive instrument, right? Or they can make a executive. Yeah. So there's in the past we had like a strict distinction between executive instrument and legislative instrument. And executive instrument was just supposed to be, if you like, the means by which the executive will implement certain laws, will implement certain policies and all that. But in modern time, the line between executive instrument and LI is somehow blurred out, because there are some executive instruments which can even be seen as having some legislative character, as it were. And the same thing applies to constitutional instruments. So coming back to Article 11, Clause 7, question of me, my position is that constitutional instruments must also be laid for Parliament, because it is part of the subsidiary legislation contemplated under Article 11, Clause 7. And every delegated legislation should be so laid, except that if we look at the recent Supreme Court decision, which I actually put it before you, concerning directives by the Bank of Ghana, and then where some different interpretation is being put on it. And I hope that you'll be able to run your eyes through the judgment, which I posted on the WhatsApp platform. Yeah, so my position is that CI should be laid before Parliament on the day that is gazetted for 21 days. Unless we have like a Supreme Court interpretation, which will try and discriminate between certain types of constitutional instruments. Otherwise, at this stage, my position and my advice is that constitutional instruments, just like other forms of delegated legislation or subsidiary legislation, should be laid before Parliament for 21 days and be gazetted on that day as well. Okay, I think we need to move on, unless, okay, let me see some hands. Okay, Eddie, you want to say something? Otherwise, we need to move on. Nee, you want to say
No, a Jusem generis. If you look at the 11.7,
yeah,
yes, the interpretation. If you look at it, it didn't talk about subsidiary legislation. It
right.
was talking about legislative instrument. So by what you taught us about rules of interpretation,
Yes.
if you look at it, it wasn't talking about executive instrument. It wasn't talking about, because it excluded them, and it wasn't talking about subsidiary legislation, but it says a legislative instrument. So, well, I think it's debatable. So let's leave it here. Let's move forward.
No. Let's look at let's look at 11.7. It says that any order, rule, or regulations, right, made by a person or authority under a power conferred by this constitution or any other law. So, conferred by this constitution, so definitely that would be like the constitutional instrument, because if we look at most of the places in which some independent bodies or some institutions or officials have been asked to make certain rules, oftentimes we see that they are directed to do so by means of constitutional instrument. So that is subsumable under Article 11.7. Okay, and then, or any other law. So maybe like an act of parliament saying that you will make laws by legislative instruments or some regulation or something like that. Yeah. So for now, my advice is that so long as we don't have any authoritative pronouncement, right, by the Supreme Court on whether constitutional instrument is excluded from the Article 11.7, I will advise that it is safe and prudent to see it as being one of the subsidiary legislation or regulatory legislation. The word subsidiary legislation or regulatory legislation is not used in Article 11.7, but the import, the essence, is what is reflected there. When we say subsidiary or regulatory legislation, what do we mean? We simply mean that we have like a primary organ for lawmaking, and that is Parliament, the legislature. But we also find laws made by some other bodies other than the primary lawmaking organ. And the other bodies that do those laws, we say the laws that they make, we say is a delegated legislation, subsidiary legislation. So that is the concept. Okay, so let's move on. We still have some hands up. Okay, Francis, and then then we'll move on to the next question. Yes.
Yes, please. So the case that you sent to us on the platform, that is the Association of Finance Houses against Bank of Ghana. It's a very
good.
Sorry, sir.
Have you been able to read
it? It's a very instructive case.
Right.
Yes, please. I have read everything.
Right.
Yes. And I think it's a very instructive case that can really resolve all these dilemma that we are facing this evening. When you refer to subsidiary legislation, it is actually a delegated power, because it is Parliament that is supposed to make laws. So where you have the Constitution itself delegating power according to Article 11.7 or any other law which can be an act of Parliament also delegating power to somebody to make law, the question then becomes which of them are supposed to be laid before Parliament according to Article 11.1c and Article 11.7. So when you read that case, it has been dealt with explicitly. There is no time for us here to expatiate on that. I will encourage my colleagues to try and read that case. It will answer all these questions.
All right, thank you very much. Thank you. Okay, so
Doc.
Yes.
Yes, I haven't read the case he spoke about. Maybe if that will be posted again. But just once we're talking about the distinction between legislative instrument and the executive instrument, there's this case that I read some time ago, which ex parte Bombele. The court attempts to Bombele, Republic versus Minister for Interior, ex parte Bombele. where the court tried to distinguish between legislative instrument and executive instrument. It made the point that the legislative instruments are those that are legislative in character and not executive in character. Let me this is just a short quote. It says to fall within the definition of Article 11.7, an order must be legislative in character, or that is a legislative order. Although a statutory instrument, an EI is not legislative or executive in character. Since executive instruments do not partake the form of rules and regulations, I would think that they fall outside the orders which are to be laid before Parliament.
Eddie, can you type the full title of the case?
Of the case, okay.
Yeah,
okay. The court distinguished between the two types of statutory instrument, that is EI and LI. So where it is an LI, it has to conform with 11.7. Where it is not, it doesn't have to conform with 11.7 procedure. That's okay, but I'll type it. But I need the other case too, if I could get it. Okay, thank you.
Are you on any of the WhatsApp platforms yet? Eddie? Okay. All right. We've lost this party bomb. Okay, let's move on. I told you that this is going to be a very short class. So after the next question, then unfortunately we have to end for the night. Tomorrow I'll try and create more time so that we have extended discussions throughout the latter parts of the evening. So let's take question 7 as our last question for the night. In the case of Salah against Attorney General, the court held that a judge will be disqualified from hearing a matter. A, if there is an inkling that he is likely to be biased. B, if we can establish a real likelihood of bias against him. C, if the jury find that he should be disqualified. D, none of the above. Remember Salah against Attorney General. Yes, Salah against Attorney General. It's only Eddie who remembers that this is a standard constitutional law case. When we are discussing the effect of constitution, coup d'etat on the pre-existing constitutional order, where the Attorney General went to town to invoke a lot of Kelson's argument and things like that. So only 2 people are contributing, Eddie and Nenebi. Okay, so okay, Eddie, and then when you finish, Nenebi. Okay, Saint Mugai is here. Okay, that's in Mugai. Yes, please.
About Salah and Attorney General.
Yes.
That case is predominantly about the effect of revolution on existing legislation. And the issue was about an act that existed where there was a judgment, or there was a gray area in respect to what constituted established, because it was said that all agencies which continued in force after the coming into office, after coming into effect of the 1969 Constitution shall remain as it is. So the interpretation about coming somehow shady. What about the
all right, thank you, Saint Mugai. So let's thank you very much. So let's get back to the aspect relating to the natural justice argument. Yes, Nenebi.
Hello.
Yes, we can hear you.
Yeah, what it is that the Salah versus AG established two fundamental principles. As you said, you mentioned the first one, which has to do with the effect of a revolution or a coup on existing legal system, whether it affects the ground norms and it destroys it entirely or not. That is one aspect. And then the other aspect has to do with nemo judo, because at the time when the Chief Justice, took an action, then the concern was whether he was in a position, because of issues of bias, nemo juda in causal sua, whether the judge is in a position that contradicts natural justice, the second leg of natural justice principle, and the court held otherwise. So those were the two fundamental principles that it laid. So it has to do with likelihood of bias.
All right, thank you. So thank you. Nenebi or who spoke? Was it who just spoke? Is it Eddie or Nenebi?
It spoke.
Sir,
All right. Okay. All right. Okay. All right. Thank you. Yeah. So if we look at the options, assuming you had even forgotten Salah versus Attorney General, right? We haven't read it, and you understand the doctrine or the concept of natural justice. If you go through the options, you can apply common sense to get the correct answer, even if you haven't read the case. So that is what I usually call like the elimination method. So in the case of Salah against Attorney General, the court held the judge will be disqualified from hearing a matter. So the fact that the question has even said that the judge will be disqualified from hearing a matter, it makes it easier for you. Just look at the options, and you can even cross out the most unlikely one. If there is an inkling that he is likely to be biased, there's an inkling that is, is it a feeling, the gut feeling that is likely to be biased? How do you actually prove that? So that is highly subjective, so that will not be it. B, if you can establish a real likelihood of bias against him. So if you have an evidence and then applying some kind of like a objective or reasonable test to that objective, you can establish that there's a real likelihood that you cannot be unbiased if we were to preside over the case. Then the normal Judas Casa Sua is going to suffer. So let's test the B against the rest.
So the answer is B.
Yeah, the answer is B, but let's test it against. Now I'm just trying to use, the answer is B, but I'm just using a strategy. If you didn't even know the case and you understood the requirements of natural justice, you should still be able to get the answer. C, if the jury find that he should be disqualified, how can a jury make a determination as to whether a judge is qualified or not qualified? Even when you are doing a jury trial, it is rather the judge, when there's a challenge for cause, who may have to inquire into whether a particular jury will have to be made to step down and so on. So C is not correct. And D, none of the above. It's difficult for you to say it's none of the above, because if you look at the B, it's very compelling. If you can show that there's a rare possibility, a rare likelihood that a judge is going to be biased, then he should be disqualified from hearing a matter. Okay, so as I told you, we're going to church on Sunday, so we need to end here, and tomorrow you continue again. So thank you very much and have a very good night.